Hello everyone, welcome to online learning session of subject Law of Crimes First, Indian Penal Code. Topic number 1, concept of crime. So we'll start with the first part of our online learning session, concept of crime. Before starting with concept of crime, we must know what is meant by crime. Crime is an act which is said to be against the society. Crime is an act against the moral order, against the rules of the society. So we can say that it is anti-social act. It is violation of laws may amount to crime. So whenever there is violation of laws, it may amounts to crime. Before discussing about crime, we must know what is meant by law. If we see the definition given by Austin, he says that law is a command of sovereign having sanction behind it. So law is, first thing, it is a command given by sovereign authority. It is a command which is backed by a force that is known as sanction behind it. So whenever there is any command issued by any sovereign or supreme authority, such command may amounts to law. So there are so many types of laws. There are so many authorities within the society who can issue such commands. Law is divided in different parts such as public law, private law, religious law, moral law, ethical laws. So whenever there is violation of any of the laws, such violation may amounts to wrong. So before discussing about concept of crime, we must know what is wrong. Wrong is nothing but violation of laws, the laws of the society. So some laws which can be known as civil laws, some laws which can be known as criminal laws, some laws which can be known as religious laws, or even moral norms can also be considered as moral laws. So whenever there is violation of any law, it may amounts to wrong. But all wrongs may not be considered as crime. If there is violation of civil law, such wrong will be considered as civil wrong. If there is violation of any religious norms, it may amounts to religious wrong. If there is violation of moral principles of the society, it may amounts to moral wrong. But whenever there is violation of any criminal law, it may amounts to wrong or criminal wrong or crime. So we must know what is meant by criminal wrong. Criminal wrong is known as crime. The concept of crime or the term crime is derived from Latin word crimen, means offense and also wrongdoer. So whoever commits any offense or whoever does any wrong, the wrongdoer may be considered as crime, or the offense can also be considered as crime. Crime is a criminal wrong. Why it can be considered as criminal wrong? Because the criminal law prohibits such things on pain of punishment. So in case of criminal wrongs, such wrongs are punishable by the law. The wrongdoer is liable for punishment which is imposed by the law. If we see the difference between civil law and criminal law, civil law provides a remedy for infected person. However, criminal law provides punishment to the wrongdoer. Whenever there is violation of criminal law, it may amounts to crime. It is very difficult to define what exactly mean by crime. But some of the criminologists, they have tried to define the concept of crime. We will see some of the definitions given by the criminologist, in which the first definition given by Sir William Blackstone. According to Sir William Blackstone, crime is an act committed or omitted in violation of public law forbidding or commanding it. If we see the definition given by Sir William Blackstone, it says that crime is an act which is either committed or omitted. There is any act which is either committed by a person or omitted in violation of public law. Public law means the law which governs relation between general public. There are two types of laws, public law and private law. Public law, that is the law which governs relation between public, and private law, that is the law which governs relation between two individuals. As per William Blackstone, an act committed or omitted in violation of public law, that is the law which forbidding or commanding it, may amounts to crime. However, the scope of the definition is limited only with the public law. So, Sir William Blackstone has given another definition so as to widen the scope of concept of crime. The second definition given by Sir William Blackstone, it says that crime is a violation of public rights and duties to the whole community. Instead of public law, Sir William Blackstone included the word public rights and duties. Public rights and duties which is either given under public law or private law. So the scope of definition was widened by Sir William Blackstone. Second definition is given by Professor Kitan. He says that crimes are wrongs whose sanction is punitive and in no way remissible by any private person, but is remissible by Crown alone if remissible at all. As Professor Kitan, crimes are wrongs whose sanction is punitive. Punitive in the sense punishable. If any person does any wrong and if the wrong is liable to be punished, then such wrongs can be considered as crime, provided that such wrong in no way remissible by any person, private person. Remissible means it can be set aside, it can be compromised, it can be waived off by any person. Crime is an act which cannot be compensated, which cannot be remitted by a private person. Crime is an act against the society, so individuals does not have any right to compensate or to waive the right against the criminals. So it is not remissible by private person but is remissible by the Crown alone. However, such wrongs can be remitted by Crown. Crown in the sense we can take it as a superior authority. The superior authority has a right to remit it and they can also remit it at all. So such type of wrongs can consider as crime. According to Stephen, crime is an act which is forbidden by law and revolting to the moral sentiments of the society. In this case, Stephen has introduced one important aspect of crime, that is, crime is an act which can violate the moral sentiments of the society. Whenever there is violation of moral sentiments of the society means whenever there is violation of certain moral norms, such norms which are prohibited by law can considered as crime. Mr. Justin Miller, he also says that crime is a commission or omission of act which the law forbids or commands under pain of punishment to be imposed by the state. According to Justin Miller, crime is the commission or omission of act which law forbids or commands, that is prohibited by law or either commanded by law under a pain of punishment to be imposed by the state. That is another aspect which is introduced by Justin Miller, that punishments can be imposed by the state. So in case of criminal law, the sanction can be enforced at the instance of the state. Then another definition given by Raphael Garfalo, he says that crime is an immoral or harmful act that is regarded as a criminal by public opinion because it is an injury to so much of the moral sense as is possessed by a community, a measure which is indispensable for the adaptation of the individual society. So crime is an immoral or harmful act. Basically, what is crime? So crime is an immoral act, crime is an harmful act that is regarded as criminal by public opinion. It is an act which is considered to be harmful act to the society. It is an act which is said to be criminal by public opinion because it is an injury to so much of the moral sense as is possessed by the community. Again, Garfellow, he also included the same word which is included by Stephen, moral sense, moral sentiments of the society. So crime is an act which is against the moral sense which is possessed by a community, which is indispensable from the adaptation of the individual society. So whenever there is violation of moral sense, it may amount to crime. Another definition given by Professor Kitan, he says that a crime today would seems to be an undesirable act which the state finds most convenient to be corrected by institution of proceeding for the infliction of a penalty instead of leaving the remedy to the discretion of some injured person. According to Professor Kitan, a crime would seems to be an undesirable act. Undesirable act, that is mean by unexpected, which is not presumed by any person, it is not expected by any person. Such undesirable acts which state finds most convenient to be corrected by institution of proceeding. Means in this case, state is the authority who can correct such undesirable act by way of inflicting of penalty by institution of proceeding. Means after institution of proceeding, before proper forum, the state can correct such act by inflicting penalty on the person instead of leaving the remedy to the discretion of some injured person. Means instead of giving the right to the injured person to compensate or to waive the remedy, the state takes initiative in such cases and they can institute proceeding for the purpose of inflicting penalty to the wrongdoer. Such type of undesirable acts may amount to crime. There is one another definition given by Professor Osborne. He says that crime is an act of default which tend to prejudice the community and is forbidden by law on pain of punishment inflicted at the suit of the state. Again, the same thing is provided by Professor Osborne. Crime is an act of default which tend to prejudice in the sense causing damage, injury to the community. It may amount to injury to the community and is forbidden by law. It is prohibited by law on the pain of punishment which can be inflicted at the suit, that is by the institution of proceedings by the state. From all these definitions, we can generate certain characteristics of crime, such as crime is an act or it is an omission which is either forbidden by the law or commanded by the law. So first thing, in case of every crime, there is either act or omission. Act in the sense to do something, omission something not to do something which is compelled by law, which is imposed by the law. So whenever any person is commanded to do any act, if he omit it, it may amount to omission. And whenever any person is forbidden from doing any act, and if he does the act, it may amount to crime. Crime is an act or omission which is either forbidden or commanded by the law. That is the first thing. Second thing, it can be violation prevented by sanction of punishment. The second important aspect of crime, that all crimes are liable to be punished. So the sanction behind every criminal law, that is the punishment. So whenever any person does any act which is an offense, such person is liable for the punishment. And third important thing, wrongdoer punished only after following procedure established by the law. That is another most important aspect, that the punishment should be as per the procedure established by the law. That means the procedure must be already defined in the law and the state or the authorities need to follow the procedure. Arbitrary use of punishments or arbitrary use of sanction is not allowed in case of crime. The person must be punished only as per the procedure given by the law. And the procedure says that or the proceeding can be instituted by the state in a proper court After hearing of all evidences, if the person found guilty, then only punishment can be inflicted on such person. So such wrongdoer must be punished only after following the procedure established by the law. So these are some of the important characteristics of the crime. Now let us see the nature of crime. As we have already gone through the definitions given about the crime, but all these definitions are not static. Basically, the concept of crime is not static. It is changing with the society. It is changing with the time. So it is very difficult to define what exactly mean by crime. The definition of crime changes as the society changes. Even though the definition given by some of the criminologists is up to some extent is proper, but it is not applicable for all type of crimes, because the crime is not a static concept. It changes with the society, it changes with the person, it changes with the area, it changes with the country, and even religion to religion. So it is very difficult to define what exactly crime, because a crime for one person may not be crime for other. An act which is crime in one country may not be a crime in other country. Similarly, a crime in a particular religion may not be a crime in other religion. The changing nature of the concept of crime makes it difficult to define what exactly crime is. The crime, in general, we can say that crime is an act which is against the society. Crime is an act against the person. Crime is an act in violation of law, and it is the act which is liable to be punished by the law. At the end, we can conclude with that crime is an harmful act to the society. Crime is such an act which can violate the moral sentiments of the people. Crime is an act which is against the morality, moral principles of the society, social order, and such act which is liable to be punished by the law.